reality. The government, through the Ministry of Economic Growth and Job Creation, is building hope, one home at a time.
Jamaica's first broadcast museum is completely online. The PBCJ Audio Visual Library AVL website houses a curated collection of exhibits ranging from our island nation's greatest tragedies to our proudest triumphs. Explore rare video footage. The evolution of archival equipment, and deep dives into the lives and times of key figures and institutions in Jamaica's storied history. It's a treasure trove for the curious and nostalgic alike. Soon, you will be able to listen to the exhibits as we continue our commitment to enhancing accessibility features. No walls, no boundaries, only rich Jamaican history curated specifically for you, accessible anytime, anywhere, anyplace. Scan the QR code or visit library@pbcj.com to experience history at your fingertips.
Join your big sister Raquel as she reintroduces the cast of Vibrations and their educational adventures to the screen. See Ronson and the gang experience the world firsthand through interviews and interactions. Vibrations, where kids are taught about the world from someone they can relate to. Join us every Friday at 3:30 p.m. to hang out with your big sister Raquel and the kids of Vibrations. Right here on PBCJ, the People's Station.
In our Funded and Focus feature, there is no question that technology is the best friend of solopreneurs seeking a path to greater funds. Think about it. AI-supported subscription programs makes it easier to convert one-time services into monthly or annual programs by automating parts the client values regularly. For example, AI can generate performance summaries, identify trends in a client's business, or suggest improvement strategies each month. This reduces the time required to maintain a subscription service while increasing perceived value. Over time, clients remain engaged because they continuously receive insights and updates that help them make better decisions.
In a world full of noise, it's easy to miss what really matters. That's why we're here. Why It Matters. Discussions that break down the issues you didn't know you needed to know. The stories overshadowed, the facts you were never told, and the topics too important to ignore. Credible, clear, connected to your life. If you've ever wondered what's really going on and why should you care, this is the show for you. Why It Matters. Because understanding the world, our world, starts with asking the right questions and getting the answers from the right people. Why It Matters. Only on PBCJ, the People's Station.
Zoom in on the nutrition facts. It there in the table on the side of the back. If you check out the servings, just do the maths. Not taking too much, finger below the facts. Zoom in on the nutrition facts. It there in the table on the side of the back. Take note of the sodium, the sugars and the fats. 5% or less in the on the right track. You for zoom in on the nutrition facts. It there in the table on the side of the back. Vitamins, minerals and vitamin 2, 20% and more that good for you. Nutrition facts. You feel check the nutrition facts. You feel check the nutrition facts. Less sugar, less salt intake, and less fat. You feel a message from the Ministry
Ministry of Health and Wellness, Jamaica Moves, the Heart Foundation of Jamaica, the National Health Fund, and Japan.
Hey, I'm Abijah, the Roots Man. Today, I want to talk to you about something powerful. Peace. Peace isn't just the absence of conflict. It's about kindness, understanding, and respect. It starts with us. Every choice we make can build bridges or burn them. Let's choose peace in our words, our action, and our hearts. Peace begins with you. Together, we can create a brighter and safer future for everyone. Join me. Let's be that change we want to see.
What is the role of a backbencher in government? I'm glad you asked. They're members of parliament who are not appointed to cabinet. So they sit in the back of the legislature and they apply pressure. They examine what government legislates, participate in parliament debates, raise issues and advocate and question chamber when things don't look straight. Backbenchers represent the constituents in parliament. Backbenchers oversee the interests of citizens, you and me. But how can they be agents of government accountability after them no hold a portfolio? And them and a minister? No. So then how can they facilitate government transparency? And the next thing.
The challenge.
How them affect me? You see, a lot of work is in committees. So these portfolio-free MPs with less dire responsibilities are more accessible.
The supporting technical team from the Ministry of Justice and Constitutional Affairs invited guests to make submissions. As we gather, we would just like to ask you to grace us with your presence, grace us with your guidance and advice and wisdom. Allow us to deliberate today in a meaningful way that will result in a very strengthened report that will allow for the amendment of the Child Diversion Act. Bless this session this morning. Through Jesus Christ we pray. Amen.
Amen. Thank you, Ms. Wigan. The meeting today, we hope to get through a fair amount. We had invited back Mr. Barnes, and we will begin with him later. But just to the apologies, we had apologies from Miss Honorable Cuthbert Flynn and also Honorable Tova Hamilton. So others are here, and we expect maybe others to join us online. Online, who do we have? Senator Golden Campbell, Senator Dana Dixon, and Dwayne Smith. So others can either join online or be here. One of the main things today, by the way, though, is the overview of the Act. We're going to go through, and I really hope members will stay with us as we go through the different sections, because we're going to identify, we're going to go through each section, but note as we go along the sections that have been attacked or needs revision or amendment, so that we're not going to debate now the amendments, but just to identify and to note that these sections may require further and fulsome consideration at a later time. But as was requested by Senator Shireen Golden Campbell, we should go through what the various sections say, and then after that, we, at a later date, we then go through the consideration of the various amendments. So there's no doubt we will be able to identify maybe 10, 15 sections that, we will need to have much further debate on. But so before, we were expecting the Jamaica Psychological Society, but they're not here as yet. So what we're going to do is to go with Mr. Daniel Barnes, who is a young man, a young student from the University of the Commonwealth. And he made an excellent presentation when he was here last time. And he had some additional comments. And also, he wanted to return to make some additional points. And I was happy to ask him to return, because when he made this presentation, I thought they were very useful. So, Mr. Barnes, without further ado, we're going to ask you to proceed and maybe highlight the additional matters that you wanted to bring to the committee's attention. Okay?
Thank you, Mr. Chairman.
You have a PowerPoint.
No, sir.
Oh, no, there's no PowerPoint, so go ahead.
Mr. Chairman, honorable members of the Joint Select Committee, all members from the relevant ministry, good morning. I am Daniel Barnes, as Mr. Chairman has said, a university student at the University of the Commonwealth Caribbean. And today, I will like to say thank you for the opportunity to once more return. I do believe that this is a very significant opportunity, and I do not take it lightly. So thank you. I want to turn the honorable members' attention to page 2 of my proposal. And it says, proposed TIA framework. On my first session, there was a recommendation for a fleshed out version of the TIA system. I have returned with a fleshed out version. And so Tier 1, referral authority. When I speak about school administrators, I speak about a subcommittee being formed in school. Later on, I will elaborate more. Social workers registered and the community-based organization, and this could also be extended to the office of the DPP. And now the process. So the referral to constable. So the offense is made, and the school subcommittee will record the offense and do the relevant documentation and refer that child to the constable for diversion program. Now, what the constable can do is the constable can caution that child as well as to direct entry into the diversion program, no charge and no court appearance. Now, examples of these offenses are school fights, no weapon, no grievous harm, petty theft under 50,000, then this can be adjusted accordingly. Trespass, minor vandalization, as well as first-time cyberbullying. Now, let me give an example of the Tier 1 case, and I will give a real-life example. So, more recently, the Jamaica Observer would have reported a student admitted to stealing items, jacket, glasses, money from a schoolmate approximately 2 weeks before the incident. When initially to questions, he denied involvement. He later acknowledged his actions and committed to restitution. He returned some money and items, but failed to make a full restitution and missed several agreed deadlines. Now, aggravated students confront him on school grounds and physically assault him. 2 boys slapping with palm and belt. Now, the incident was recorded and posted to social media and sparked public outrage. Now, within the proposed Tier 1 framework, what this allows for is that the school disciplinary committee legislates, the school-based diversion subcommittee documents the incident. The committee refers the matter to the assigned constable, who is already a member of the subcommittee and is considered as the school resource officer. The constable seeing the offense falls under Tier 1 in the schedule cautioned the child, this is not an arrest, this is not a charge, but a formal warning documented only for the purpose of the diversion program. The child accepts responsibility, and what this means is acknowledging that they would have done wrong and they will take responsibility, but not an admission of guilt for the offense, and is immediately referred to the diversion office for programming. The child completes the program, which may include anger management or the appropriate diversion mechanisms by the ministry. Upon successful completion, there is no criminal record. The matter is closed. The only record is internal to the school and the diversion office for monitoring purpose only. Now, crucially, if the child fails to complete the program, the constable retains authority to formally charge the child and bring them before the court. The safeguard remains, but we have provided an off-ramp that currently does not exist in a clear legislative form. Now, Tier 2 explain. The constable only. And so a charge may be laid, but referred before court appearance. Program completion successful, no criminal record. And offenses, examples, assault occasion to actual bodily harm, theft of amounting to 51,000 or more, possession of small quantity of cannabis, and repeated cyber offenses. I would like to give an example with just the recent incident of the slap and the belt, and so that would be a Tier 1 offense, and only the constable would be able to refer based on the investigation and the findings of the investigation if the child is eligible for diversion. And now, within the Tier 2 eligibility assessment, referral to program, court proceeding stayed suspended. So the court matter is held in abeyance pending completion of the program, and this is on page 3 under Tier 2 explain, and the charge is expunged. The charge is formally withdrawn and expunged from the child's record, leaving no criminal history. Now, Tier 3 explain. Court only. Child must be charged and appear before court. Court refers to diversion program if appropriate, and the offenses are involving in weapons, grievous bodily harm, sexual offenses, offenses against younger children, and serious repeated offenses, and any other offense that warrants the full life sentence or the full penalty of the sentence. Now, within the Tier 3, explain. At Tier 3, the child is already before the court, meaning the matter is more serious. The child may be a repeated offender. No. The child is brought before the court. A pre-sentence assessment. Before a plea is entered or a sentence is imposed, the court orders a social inquiry report or a risk and needs assessment. The child is not obligated to give an admission of guilt, but rather acknowledge and agrees to participate in diversion program. No, the court ordered referral. The judge, satisfied that the child is suitable, formally diverts the child to the appropriate Tier 3 intervention program. No, the Director of Public Prosecution, for the purpose of sentencing, enhances respect to new offenses committed. And so what we are looking at is also ensuring that the matter is adjourned. So the court adjourns proceeding for a defined period. Restrict access. So within the court, we have a restricted access. And so the issue that was raised in the last session that I was here was, how can we ensure that children who comes in conflict with the law are not formally in the justice system, but diverted without the formalization. And so matter adjourned. The court adjourns proceeding for a defined period. This allows for the diversion process to take place. No. Restrict access. This means the record exists but is sealed from the general public. Cannot be accessed by employers, schools, or landlords. And this was an issue that was brought up about how can what was referred, for want of a better word, the stain on the child, how can it be appropriately? And so only access by, and this is on page 5, only access by the law enforcement as well as courts in future juvenile or criminal proceeding. Specified government agencies ordered by court can also access the records. After a defined period of good behavior or reaching the age of 18 or 21 with no reoffending, the restricted record can be converted to a full expungement automatically by application or by the time period. So the committee can allot a time period where we say 5, 6, 7 years after good behavior, and then it can be expunged or it can be applied for. All right, so I won't stress too much on sealing of record, but on page 5 it says, Section 11A, sealing of record, my recommendations for a successful completion of the diversion for a Tier 3 offense. And what I want to point out is that the court shall issue an order sealing all records relating to the charge, the finding of guilt, and the diversion program. I now move on to school-based subcommittee. Through you, Mr. Chair, are there any questions? Are there any questions based on... thank you, sir. So, the school-based diversion subcommittee fleshed out proposal. So, clear jurisdiction, and we would observe online what has been happening currently now with both school cases, and we realize that there's a clear gap within the school system about how to treat with the matters, because a release that was made by one of the institutions said that the disciplinary committee would give the appropriate disciplinary decision. But what does that mean? I am a member of a disciplinary committee, and when it comes to the committee, it is suspension or expulsion. So what are the appropriate disciplinary measures that a committee can take at school? And so I am giving clear legislative pathway for that. So the subcommittee shall have jurisdiction over Tier 1 offense only. The alleged conduct occurs on school premises. We have seen in both cases where the origin is in school, one is off campus and one is on campus. And so, including the school building, grounds, and school-owned vehicles. The alleged conduct occur on the school-sponsored activities, whether on or off school premises, provide the child under supervision of the school staff at the time or circumstances. So the alleged conduct begun on the school premises and continue immediately thereafter in circumstances directly connected to the school environment. And for the avoidance of doubt, the subcommittee shall have no jurisdiction over conduct that occurs outside school premises during non-school hours, even where both parties are students. And now, timeline and process. The subcommittee shall convene within 3 school days of the incident being reported to the principal or the vice principal. The referral form, I believe that one should be promulgated, shall be completed and submitted to the assigned constable within 5 days of the incident being reported. Where the assigned constable does not respond within 10 school days of receiving the referral, the subcommittee shall escalate the matter to the diversion office in writing. The subcommittee shall provide written notice to the parent or guardian of the child with 24 hours of the subcommittee convening, and no substantive meeting with the child shall occur until the parent or guardian has been notified. Now, a clear function. The subcommittee does not adjudicate. Its function is to A. Document the incident. B. Ensure the child rights are protected. C. Make the referral to the constable during the prescribed form. And D. Monitor the child's participation in the diversion program. And I move on to training requirements, because I believe that this is crucially important. Members of the subcommittee must complete training by the Child Diversion Office on restorative justice practices, child rights, and referral process. No member of the subcommittee shall exercise any function under this section until they have completed training approved by the Child Diversion Office covering restorative justice practices, child rights, the referral process, and the rights of a child under this Act. And training shall be renewed every 2 years. and confidentiality. I believe that this is key importance. All records of the subcommittee, including referral forms, incident reports, and meeting notes, are confidential and shall not be disclosed except to the assigned constable for the purpose of the diversion referral, to the child diversion committee or a child diversion office for monitoring purposes, to the parent or guardian of the child. So, and also to the pursuant to a court order. It says, records shall not appear on the child's academic report, school leaving certificate, or any document issued to a prospective employer or educational institution. Where the child successfully completes the diversion program, all subcommittee records relating to the matter shall be sealed and accessible only under Section A4. So, in my first submission, I would have given the proposed amendment about the subcommittee within schools. And today I bring a clear legislative function, how the school subcommittee would operate.
So your submission, basically carrying over from last time, is trying to tie in how child diversion would operate alongside the Child Care and Protection Act, right?
Yes, Mr. Chair.
All right. The truth is, a lot of what you have suggested now comes into the child diversion program, which has been, assessed and checked on. And so what is, with what you're suggesting is that tying in how you move forward with child diversion. So a lot of their suggestions which you're putting forward now have been looked at, okay? In terms of what could be done with child diversion, okay? So is there any particular point in the, because we have your document, that you think, that you think you want to bring to the committee as the most prominent point, you understand, that you would see legislatively should be dealt with?
I believe that most of the recommendations, and I'm happy because I watched the proceedings yesterday and I was happy with the CS as well as JCF and the recommendation, and I believe that my submission also strengthens the recommendation.
Right.
And there was in the closing age relation provision, I believe that point was not fully expressed, and so within my submission, it gives more detail as to the age in terms of just 2 years, and it also can be tied into the framework where this can be broken down in tiers as well for constable and the courts only. So in the enclosed age relation provision or consensual sex between minor, 12 to 14 can only be dealt with as the court matter, and from 15 to 17, the constable can refer to the program.
Right.
And so if a child is, say, 15 and 14, then it will go to the court because you're going to use the lowest age as the determination.
Right. So, glancing, perusing your submission, a lot of the recommendations tie in with what, as you know, has been provided by several presenters already, okay? But your point on the closing age, to be frank with you, the recommendation that has been made to Parliament already, which is still to be acted on, but very likely is not 2 years, but 4 years. And the reason for 4 years, when it was considered by Parliament, they were looking at 15 and 19, a 19-year-old fellow boy, say, with a 15-year-old, because the law now provides, if that fellow, if any offender, a boy who is under 23, has good grounds to believe that the child is over 16, it's a defense. So we didn't go as far as 23. We said 4 years, up to 19, because that is the sort of closing age that we thought 4 years would suffice. But as I say, the law provides that if the young man, maybe because we're talking consensual relationship, for whatever reason, believe that the young girl is over 16 and over, it is, if they can convince a jury and the judge, that is a good defense. You understand? But we said when we debated it a long time ago, 2017, that we wouldn't put 6, or at that time it would have been about 7 years. We reduced it to 4 years. But your proposal, 2 years, I mean, can be considered, but the truth is that what is before the Parliament, which Parliament accepted already, was a 4-year gap. Okay? Colleagues, would you like to
ask him something? Not. I noted, Mr. Barnes, and I thank you for making this presentation. It's good to see someone so young coming to the Parliament. Right. When you were talking about the disciplinary committee, you specifically excluded any matter which took place outside of the school. You said that school hours, and I assumed it would be like if you, I went to Clarendon College, so it would be like you're in the town and there was misconduct there or anything like that, which amounted to a commission of an offense that would arise under the Child Diversion Act. You felt that the disciplinary committee should not have anything to do with that. And I was really intrigued by that, because when I was going to school, part of what kept young people in check, I was a head girl, was that you were wearing your school uniform. And with that, it demanded a particular type of conduct from you, which would reflect your school. So I was just interested in what made you come to that conclusion, having regard to the fact that I left school so many decades ago.
And to add to that, Mr. Barnes, I support what Senator Motley is saying. Most of the misbehaviors of the school compound. On the school compound, there generally is fairly good behavior because teachers, headmaster are there, but it is off the school compound that you get a fair amount of misbehavior. So why would you want to restrict it to just...
Thank you so much, Mr. Chair and Honourable Member. I believe you have identified a key gap within my proposal, and so we can adapt to also allow for it to be just as you would have stated. So key gap identified, and so we can adapt.
Okay. Member,
Mr. Barnes, you know, bullying is a big issue in Jamaica right now. I'd hope that the goodly senator and the chairman didn't bully you to say that there was a gap. I'm not your lawyer, but two things I wanted to raise. On the same point, very intriguing. You went as far as saying that the authority, basically of the board, internal, the disciplinary remedies would be expulsion and suspension, and you raised some concern with that. Now, my question to you, though, is are you saying that conduct outside the school would strip the school of the right to expel or suspend? That's the first question.
Not necessarily, no. It would not restrict the school to expel.
Okay. Now, in your proposed tiered referral framework, you had tier 3. The aspect of court only. I just wanted to look at it again, because it was kind of concerning, because it sounds as if you're saying that the police wouldn't have the authority to divert. And one of the most sensitive areas in child diversion is actually the sexual offenses. And so if you're saying that it's a mandatory charge, wouldn't that be problematic? If you're saying charge them and bring them before the court when the spirit of the act is to divert.
All right, so in the best interest of the child, based on the Child Care and Protection Act, and so we're looking at the premises of that. And I believe that there are some offenses that are more in severity than some, and would award a stronger penalty than most. And so looking at the bodily harm and the sexual offense, I believe that it is something that we take very serious. The offense is very serious. I would have raised an important point that it can be done in a tier base as well. And so I am not limited to what is here on paper to explicitly state that, yes, this is my proposal, but we can actually do some different work to improve. And so as it relates to the tier base, if it is a case where the constable with the investigation can determine that the offense is warranted, a tier 2 offense in terms of what I would have recommended, it's not here on the paper, but I would recommend it, then the constable can divert the age now that is given, the 15 to 17, I believe that is a more appropriate age range for a constable versus a more younger age between 14 to 12.
Okay.
All right, thank you.
All right. Go ahead.
Through you, Mr. Chair. Thank you, Mr. Barnes, for your presentation. There's just something I wanted to, just for clarity. I'm trying to find out the school-based committee, diversion committee that you're proposing. You're proposing a formal school-based committee which has the jurisdiction and legislative backing to divert. All right? And
recommend diversion.
Or recommend diversion through the constable. My question is, what currently obtains in the schools as it is now? What's the current position in schools? Well, in recent times we have had some incidents in the schools. Is it...
to be fair, what obtains in the school now is dealt with under the Ministry of Education, Child Care and Protection Act. So unless it comes to the case there that the child is in conflict with the law, it would not be referred to the constable or to diversion. Indeed, what he had proposed last time, I suspect is continuing to propose, which is what we need to look at, is whether or not, as I said, other behavior that doesn't amount to conflict in the law, but is bordering, I use the term delinquency, that the child has definitely shown delinquent behavior, whether this is something that we should include and expand, not just conflict with the law. So to the extent that there is a child who is engaged in delinquent behavior, let us say smoking marijuana regularly, it may well be that what he was suggesting is that the disciplinary committee of the school could refer to the constable. Even if the child is not charged, at least the constable can use the warning in order to divert it to the relevant child diversion officer.
Yeah, I understand it. So why I ask the question, is to ascertain whether he sees or has detected a gap or some lacking in terms of how the schools operate, in terms of handling children who have offended or who offend. Why you're proposing this more formal legislative system in the school.
Thank you so much, Honorable Member. I believe the current pathway for a school is not clear. And being a member of a disciplinary committee, there are patterns observed and brought to the committee by the guidance council.
I just confirm, you're a member of the disciplinary. You have been a member of the disciplinary.
I am a member of the disciplinary committee currently, and the guidance counselor, the dean of discipline, they observe the teachers. They observe behavior and they bring it to the disciplinary committee. The child is deemed, one for a better word, uncontrollable, and there is intervention, but not the intervention which causes for a change of behavior within the child. And so we reach out to the relevant agencies like CPFSA, restorative justice, but that does not cause a change of behavior within the child. The school cannot refer any child to the diversion program because you must come in conflict with the law. Just as proposed within the Tier 2, where the constable only caution and do not charge, but the offense was made, then we can also explore that avenue to say that these are patterns that will likely lead to an escalation of offense. And so the subcommittee, underwriting with the proper documentation of the guidance council and the dean, can refer that child as well to say, this child is on the borderline of a diversion offense.
Right. And you see, Member Williams, that is where he was the last time. And the question is, how do the CCPA legislation and the disciplinary committee, how everyone work together, and if indeed this is one that a child diversion program could be useful for that child. He was saying at the last time, which he's now recommending, that there should be an avenue to be able to get that committee, the disciplinary committee, to divert the child to child diversion. Because what happens now, which is the point, if the child is, as he used the term, uncontrollable, it actually ends up in court for the court to refer the matter to child diversion. And we are trying to get it away from the court. We are trying to see if there is a way to get the assistance, put it no stronger than that, the assistance that the child needs. And it may well be the CCPA, yes, but can it, which is what he's proposing, find a way to get it to child diversion where additional support could be given to the child to go straight. And that is why I like the argument he's put in, that there has to be a sort of midway position where you can move from the disciplinary committee of the school that has identified the behavior, but nothing happens. The CCPA still look at the child, and unfortunately, as we pointed out, too often the child is suspended or expelled, when in what could be done is, could a program be provided for the child, which is what child diversion is. 3 months, 6 months, to see if the child restore back to normal behavior and so remain in the school without being suspended or expelled. So, in a sense, colleagues, that is why I like the idea where he's saying, and because he sits on the disciplinary committee, he doesn't feel that the disciplinary committee has the avenue to really help a few individuals. So this is something we will have to assess fully. So, sorry, you want to continue?
And that is why it finds favor with me. His proposal in relation to the subcommittee resonates with me. It's troubling me because it may be the panacea to the failings which he has identified. And I think we should look at it seriously. Because it seems to me that the diversion framework could, if this route is taken, could be effective in stemming the incidences of,
or at least another level.
Yeah.
Another level. How do you not just let it stop there, but you get further assistance?
Yeah.
I know Minister Dixon is on the line. I don't know if she wants to comment, and also Senator
Chair.
Yes.
Chair, can you hear me?
Is that Minister Dixon?
Yes, it is. I've been trying to come in for a long time.
Somehow
apparently doesn't work when you're remote, so I don't know why we have
That's why I'm asking Mr. Nash to let me know when the hands are up for persons who are
There is no
virtual.
option to put your hand up, Chair.
Yeah. So go ahead.
So I was
Minister
coming
Dixon.
in, Chair.
Go ahead.
Chair,
Minister.
I was coming in to note that I want to commend your presenter for coming and giving his position. But I am obviously very wary of us extending child diversion beyond what it is. And disciplinary committees in schools do have the option, they may not exercise it, under CCPA to refer the child to CPFSA for interventions. in the situations that have come up in recent times, the CPFSA has been involved with the schools. They have taken the children, they've visited the families, visited the homes, done the psychological support, given that kind of support, and given lots of other support to the children, very similar to what happens in the child diversion program. There's just a difference between children who come into conflict with the law and those who are seen to be somewhat uncontrollable or having issues. Now, the schools, and this is something under CCPA, when we discuss CCPA, we can discuss how we can make the mechanisms for referrals better. But I think there is a clear distinction between children who come into conflict with the law, commit a crime, and those who have exhibited behavior that needs to be addressed. And I don't like the idea of them being merged together. But I know that's not for discussion here. We're just listening to our presentation. But I just wanted to put that on the table. And I'm looking forward to the time when the committee can really start discussing with each other our views and move forward from the presentations also.
Right. Thank you, Minister Dixon, because that is why we need, a more fulsome understanding of how the child moved from CCPA either to CPFSA, where, behavior, and there, as Minister Dixon said, there could be duplication, but the question arises, how can, and Minister Dixon is quite clear, you don't want duplication. So we need to find a way that all agencies can work closely together to make sure.
And Chair, if I may, just one last thing, just to note that there are, as yesterday we would have heard, there are school safety officers in the schools already. So the Ministry of National Security has police officers at our schools. And so there is a mechanism too where they already intervene in schools as police officers. So I think it's important that we understand the whole lay of the land, which is something I've been saying, so that we understand where child diversion starts and ends, where CCPA starts and ends, and where there are any gaps. And then when we find the gaps, we figure out which legislation is appropriate to do it under. And not everything has to be legislated, because I think child diversion and CCPA, in terms of some of the approaches and techniques that we're using, they're so similar that we may have to have at an administrative level conversations, not at the law in terms of the legislation, but at administrative level, how we don't duplicate efforts and we can get better synergies.
And work closer together. Member Cuthbert, you.
So thank you, Chairman. So I think what I'm hearing is that we need the different agencies to really speak to each other then. Is that what I'm hearing? Because what I'm also hearing, I want to thank you again, Mr. Daniel Barnes, for coming back and making such an excellent presentation. But what I'm hearing is that there is still a gap. Clearly, there is a gap that needs to be closed, and we need to make sure that, as you said, a lot of times we duplicate things. This agency is doing the same thing that this agency is doing. However, nobody's speaking to each other, and that gap exists where who suffers? The child then suffers, where they end up in a juvenile detention center or where they shouldn't be and possibly should have been sent to child diversion. And so I think the bigger question is, how then do we make sure that when we're, putting this legislation together, that gap with the Ministry of Education, with CPFSA, with all the different agencies and ministries, that we are closing that gap? Because again, what we see in St. Thomas, what if that child was possibly, or the two children were sent to child diversion? I don't know if we would have ended up in the situation that we saw happening. And so who was responsible for closing that gap to make sure that it wasn't just, okay, the child is then sent to another school or what have you, and it was just left? I think a greater intervention needed to possibly happen. I didn't read the entire story, but from what I'm hearing, greater intervention should have taken place. And I think that is what is missing.
And to be fair, Member Cuthbert, Minister Dixon was here yesterday to point out that immediately after we're finished with this committee, she plans to set up another committee immediately to look at the possible weaknesses in the CCPA and the CFSA, because, as she mentioned, because that requirement and to look at those acts to allow for and also to close in with the therapeutic centers, which could solve a lot of the problems we're having in the schools, where so-called uncontrollable children may well need therapy in a therapeutic center. So the point is that even before we do, when we debate, we can see how far we go, because we don't want to duplicate with what Minister Dixie is going to do with the CCPA and CFSA from the Ministry of National Security. Okay? So you can see, colleagues and Mr. Barnes, there are problems. The question is, we need to solve them. And the problem is there's sort of far too many cases of our children getting into trouble. And the question is, how do we work to resolve these problems? Senator Motley and then Mr. Buchanan.
I couldn't agree with you more, Minister. But these are not new problems that we are having. And we have established organizations which have been supposed to take care of it. I think sometimes what it calls for is just total frankness as to where we are failing. And unfortunately, governments don't like to do that, regardless of which government it is. We are at a very critical state. Our children are really suffering. And although we look at things in isolation, COVID and Melissa have piled up a lot of trauma on their shoulders, in addition to what they are experiencing in their houses. And remember, the parents also have those kinds of situations too. So the time is now for us to just be frank. Perhaps we shouldn't have any cameras so that we don't have to, be performative and defend. Just to be open. We all have the same goal, Minister. You and I share the same kind of concerns about what is happening to our children. And we just need a frank conversation, just to talk to each other like people, Jamaican people, rather than political sides, because these problems are not new. They are not new, and in the meantime, our children are suffering, and this review gives us an opportunity to just fill the gaps in the best interest of the child.
Absolutely. Thank you, Senator Martin. Mr. Buchanan.
Thank you, Chairman. I find it important to address Mr. Barnes about jurisdiction and why I have to raise it. You see, I think I'm sounding like a broken record about treating children like children. They are children. The purpose of child diversion, conflict with the law. When he was speaking, Mr. Chairman, many things went through my mind in terms of when we give power to even a disciplinary panel, how do we identify what is the behavior that we find to be criminal, and are we going to create a schedule to ensure that children's rights are not violated in the event? There's a recommendation that in his recommendation he spoke about the committee identifying child rights and saying that you tell the child the nature of the offense and how they interpret it, and then some part at D it says then the child has the right to contact parents. That's outside of the remit of the law. I'm adopting what the Minister of Education has said respectfully about keeping the jurisdiction separate, understanding that uncontrollable minors need to think about the uncontrollable parent. I keep saying it, Chairman, because a lot of the behavior, piggybacking on the Senator, is that as adults, there are things happening in society that we cannot manage. and seeing the behavior of children is only acting out in real time, things they don't understand. And so we really have to rethink. But Mr. Barnes sits on a disciplinary committee, and there's some compassion and empathy that must come while sitting on that committee, understanding that when dealing with children, I know no other place but to speak of the movie Happy Feet. We were children once, Mr. Barnes, and probably what culture is causing to appear to be uncontrollable may just be the culture of the day that we need to interpret. And I'm just saying, as you sit on the disciplinary committee, do so with compassion and empathy, because it may be the solution to a child that's acting out for attention. Thank you.
Thank you very much, Mr. Buchanan. And Mr. Barnes, I'm going to cut now because we have a few more matters to do, but to thank you sincerely for spending some time and to put in this additional submission. We certainly will look at it and see as best as possible when what can be adopted. But as you heard, we have to look at the other agencies and make sure that there are no duplication. So thanks again, Mr. Barnes. You can remain as usual for the rest of the session, okay? So thanks. Now we have the second presentation from the Jamaica Psychological Association. Could you just introduce yourself, please? But I don't know, is Senator Golden still on? Yes, she's on. Senator Golden, I understand your hand was up earlier and I didn't see it. Are you there?
Yes, Chairman, I'm still here. I was actually seeking some clarification as to the agenda today, but I think I've now gotten it. I understand we're to hear from the Jamaica Psychological Society.
And then we go to the overview.
Okay. I hope we'll be able to do all of that. Okay.
Right. No, we are hoping we have some to go to at least 1 o'clock. And maybe beyond.
I'm not sure, Chairman, that I'm going to be able to stay with you for that long.
We hope you will remain with us as long as possible. Okay.
I do have a matter at 1, Chairman, so I don't think I'll be able to stay.
Let's see how quickly we can go through, so you can allow to go. All right. The Jamaica Psychological Association. Could you just introduce yourself and then?
Good morning, Chair, Minister, and other senators and other members who are here. I am Valerie McKenzie, Director of Advocacy at the Jamaican Psychological Society. And I just want to say we thank you for the opportunity to weigh in on this very important and timely matter. Now, as an overview, we have 7 recommendations, and I will here start just to say the definition of the child, professional designation, psychological indicators, developmental level, trauma-informed approach, family system, and data protection. I will try to be as brief as I can, and so I will start with the definition of the child. I have been sitting here, though I came in at a time when Mr. Barnes had started, and gave me some food for thought because I am looking at the age gap. The Act does not expressly state the minimum age of criminal responsibility or the target age cohort for diversion, and yet coming out of the discussion here, it is that it is 12 to 17 years, and so the Act doesn't state that as such. Let me try to move this. Right. So the child diversion framework should apply to children aged 12 to 17 years, as we see in the child. We see it where UNICEF, the child, on UNICEF Jamaica's website, we see where it is 12 years old. JIS website, it tells you 12 to 17 years old, you know. And so here we know that children under 12 falls under the care and protection mandate of the Child Protection and Family Services Agency, CPFSA. So here with the recommendation, we are asking that a proviso should allow professional assessment of cognitive capacity and maturity to determine suitability regardless of the age. Whether it is 10 years old, as in some jurisdiction, criminal responsibility is 10, right? And although mainly it is 12, however, in India, it is 7 years old, for whatever it's worth. And so we need to put that proviso. We should allow professional assessment of cognitive capacity and maturity to determine the suitability regardless of age. So the other recommendation is professionalizing the counselor designation. Since April 2016, licensure for psychologists and counselors is mandatory under the Council for Professions Supplementary to Medicine, CPSM. And these people would require a master's or doctoral degree to be licensed. However, we see the term approved counselor being used throughout the Act, and this lacks clarity on qualifications and does not reflect CPSM registered categories. Hence, we are asking that, we are recommending that approved counselor in sections 20, subsection 2, approved counselor with approved, this should be replaced with approved professional counselor registered with CPSM and approved by the minister. That also goes for section 16, subsection 1J, and section 20, subsection 2A and B. Our third recommendation looks at embedding psychological indicators in evaluation. So beyond the recidivism, that is measuring the real, we need to measure the real change, right? So program completion alone is insufficient. We are recommending that evaluation reports submitted under Section 12, that is duty to make reports, should include validated psychological indicators, emotional regulation, that is impulse control and stress response, behavioral functioning, and social reintegration. So there are tools out there, tools such as emotion regulation questionnaires and behavioral checklists that can provide objective, child-centered data that validate holistic rehabilitation outcomes. The other recommendation, expanding on the other recommendation, that is centering child's developmental level. Brain development significantly affects impulse control, moral comprehension, and decision-making capacity, particularly for younger children. And so interventions should be tailored to developmental level. This demonstrably reduce recidivism compared to the mismatched approaches. So when we look at section 2.3b, acceptance of responsibility, that requires that acceptance of responsibility be developmentally informed and supported by psychological evaluation to confirm capacity and voluntariness. Section 14.1b, program design factors. We should add developmental level of the child to the list of factors considered when designing a child diversion program. So this reflects global best practice, recognizing that the cognitive ability and that developmental maturity are fundamental to fair and effective youth justice. Earlier on, Senator spoke to the trauma that we are undergoing in our society, the trauma of COVID, the disasters that we have been through. And so we need to formalize a trauma-informed approach. So the evidence is that 70.5% of Jamaican adults reported experiencing 4 or more categories of adverse childhood experiences. That's ACEs. They include family and community violence, Johnson et al. 2025. So justice-involved youth are disproportionately affected. So we find that the trauma-informed approach is absent from the Act's formal text, despite being incorporated into officer and committee training. And so we are recommending an addition to Section 15, the explicit requirement to utilize a trauma-informed approach in the development and implementation of the child diversion program. So this builds directly into the Act's existing emphasis on a psychosocial approach to rehabilitation, and it reflects the Jamaican context. We also need to recognize the central role of the family. Children do not develop in isolation, and family conflict, dysfunction, neglect, and maltreatment are key predictors of juvenile delinquency. And let me just add, I listened to Senator Motley speaking about giving an example of, students in the town of Chapelton, acting out in their uniforms. And it takes a village to raise a child, and we need to really see more of that. And so effective rehabilitation must extend beyond the individual child. So family assessment. Section 16.1, subsection 1, should explicitly require a structured family assessment as part of the diversion process to identify risk and protective factors. Family interventions. Evidence-based family interventions include structured parenting programs and family therapy, and this significantly reduces recidivism by strengthening caregiver capacity. Legislative embedding family-focused components in the Act will address root causes of offending and improve sustainable rehabilitation outcomes for the Jamaican youth. And I continue with the last one here, referencing the Data Protection Act. And I listened to Mr. Barnes, and he spoke about the document being sealed and access to that document. We have a very beautiful Data Protection Act, and this should be very explicit in the Child Diversion Act. So why it matters? Records associated with child diversion, mental health histories, offenses, family details are highly sensitive. Explicit alignment with the Data Protection Act 2020 ensures that these records are handled with the legal rigor they demand. Data minimization and purpose limitation prevent permanent digital footprints from youthful mistakes, preserving future prospects in education and employment, and critical to identity formation. And this is critical to identity formation and social reintegration. So relevant DPA sections for reference is Section 4, fair and lawful processing. Section 5, purpose limitation. Section 10, special categories / sensitive data. And Section 25 to 27, security of data. So yes, robust data protection reduces the risk of secondary trauma from data leaks. It limits stigmatization and encourages full program participation without fear. And so what are we doing? We're calling for evidence-based reform. So the Jamaican Psychological Society supports the review of the Child Diversion Act and are pleased to be a part of this revision. And we urge the adoption of these 7 recommendations to build a framework that is legally precise, psychologically grounded, and internationally aligned. So legal clarity defines age ranges and professional titles with precision. Yes? Psychological science, embed developmental and trauma-informed principles. Family and community, address root causes through structured family engagement. And rights and privacy, align with the Data Protection Act to safeguard our children. I want to thank you for listening, and here is our report.
Thank you very much, Ms. McKenzie. Very nice. Colleagues, Senator Motley.
Thank
My
you
hand
so
is up
much.
too.
Thank you so much for that presentation. It's really appreciated. And I can tell you that for me, the most significant part is a family assessment,
yes.
because I think that gets to the root of the matter. But I wanted to ask you one thing in terms of your suggestion that, notwithstanding the prescribed age range,
yes.
Determination based on an assessment of the child's cognitive capacity and maturity. Now, is it that you are suggesting that we look for a trigger, or is it that you are suggesting that all children should be subject to that? Because that was of concern to me. I don't want us to do anything that will clog up the system. I want things that will facilitate the system working. And so I wanted to know specifically whether you were saying, if you see these signs, not necessarily that would need to be included in the act itself, but is it, if you see these signs, then that is the step you should take?
Okay, so let me respond here. When we were looking at the Child Diversion Act, and we noticed that there isn't a target population there stated, and we are recommending the target population to be stated. However, I remember in the past, our past DPP has said that she has seen some heinous crimes being committed by children. And when we look at the age range of criminal responsibility, as I've said to you, pointed out that in India it's 7, right? It's 7 years, and well, the minimum. And in the UK and Wales, it's 10 years, the minimum years. We will find that outside of the 12 years, we will find 11 years and a 10-year-old or an 11-year-old being referred to child diversion. And so we wanted to give, there's that flexibility we want to incorporate, and that would have been based on the assessment from the professional. So it's not to tie it down to say, okay, you must be 12, but we find that people mature at different age. Yes.
Yeah. Sorry, you're following up.
Yes.
And then after you follow up, Member
When
Cuthbert.
we were considering the mandatory age.
Members online, please, if you want to speak, just put up your hand, please.
When we were considering the mandatory minimum
yes.
for sentencing for children convicted of murder, we did have presentations made by psychiatrists which pointed to that. But I'm still not clear, because what I'm asking for, do you want it done for all the children who come in conflict with the law and come before the program? Or is it that you're suggesting that if there is a clear, because you can discern it, if you have reason to be concerned, then you do the psychological.
We are suggesting if you have reasons to be concerned, as you have pointed out, that the system can be clogged if we are doing it for everyone. And I do believe as well that what chances there are for them. We are looking for what is best for the child. And there are times the decision might be taken that, well, this child, an assessment is deserved here. But I would think, and we are presenting, if they are under the 12, that professional evaluation needs to be done. If they're under 12, specifically, that professional evaluation needs to be done, whereas the 12 and beyond. Am I answering? Am I giving you the answer you're looking for? We have to look at the professional, we have to do that professional evaluation. As 12 years old, there are some 12 years old, they are not cognitively, developed.
Pointing me to.
You're following up.
No, yes, she asked me.
All right, go ahead.
Yes. What you're actually pointing me to is another gap.
There is that gap.
Because if there wasn't a gap, then we wouldn't be
here,
going
back and forth.
Thank you.
Senator.
Sorry, go ahead.
Senator, through the chair, if I may respond as well. As I have said earlier, everyone at 12 years old are not really mature, cognitively developed, and so give them the benefit of doing a cognitive assessment.
All right. We're going to go to Minister Cuthbert Flynn and then Senator Shireen Golden Campbell and then Mr. Buchanan. Okay, in that order. Go ahead, Minister Cuthbert.
Thank you, Ms. Mackenzie, for that, really good presentation. You mentioned a lot of things that I'm in agreement with, but I also want to find out, we do have the CPFSA who would handle the children who are under 12. But I think you also mentioned about the trauma-informed approach as far as making sure that the family is also a part of it. And one of the things I believe that we're possibly not doing, or maybe I'm wrong, if it is that a child who is under 12 years old, are we also, and what I would want to see is to have the entire family being a part of that, trauma-informed approach as far as an assessment to be done. I don't necessarily believe, even though cognitively I think some children maybe at 11 may understand more than, and this is a different jurisdiction, so I'm not sure if I'd want to go or to look at that approach. I think the CPFSA, what we need to do is to tidy up things and to make sure that we're not just putting the child who is 11 for the various, not crime, but things that may take place into a home and just put the child in the home. But I think the parents need to also be assessed in that manner and work with the parent as to whatever that is, whether it's something sexual or whatever it is, and to also evaluate what is happening in the home along with the child. And that is how we would handle that should be handled. That is what I believe. You don't just take the child away, which is what's been happening. We take the child out of the home and we're not fixing that home. That same parent may end up having another child, and the same thing happens, and that cycle continues. Now, what we need to do, and I think once and for all, is to look at what is happening in society, in our society on a whole, and fix that problem. I think, again, I would not want to see a 12-year-old or under 12 being sent to a child diversion, even with an assessment. I think this is where the psychologists will come in, and the assessment in the home would come in. But I think what needs to happen now in Jamaica is not just take the child out of the home, put them into a place of safety, we call it, and then the parent is not assessed, nothing really happens with the parent, and it is just left that way. We are not closing that gap, and I think that is where we are going wrong. So I know that the Ministry of National Security and Peace, we have the case managers who are in the schools, making assessments, working with children, but I think, and they're also working with families and working with parents in the communities. So I think where we need to do is to close that gap is between Ministry of National Security and Peace and Justice and the Ministry of Education. We really need to come together now, work together, formulate something to make sure that we are taking care of this once and for all. But let me just state that I have serious issues with children being taken out of a home, placed in a place of safety at a particular age, and the parents, nothing happens when it comes to the parents or the families, when it comes to a psychological analysis to find out what is happening in the home and to fix that. Thank you.
Okay, before you answer, Ms. Mackenzie, Senator Goldenkamp, and I understand after Senator Goldenkamp, Mr. Buchanan, and then Minister Dana Dixon.
No, Chairman, let me yield to Minister Dana Dixon because my hand is only up because she's unable to do a raise hand feature. So I'm yielding to her now.
Oh, because we didn't see her hand coming up. So she had WhatsApp me to say her hands was up. Okay, Senator, Minister Dana Dixon,
you,
and
Chair,
if you don't
and
mind, Mr. Buchanan.
Senator Golding Campbell, for putting up your hand for me because I was trying to get the chair's attention. But I just really want to thank the association for that presentation. It was a very good presentation. I think you need to assist in some other areas too. I definitely need your assistance in some areas, especially vis-a-vis how we use exams and so on. But we're talking about child diversion. And the pieces that were very important to me was the trauma-informed approach, which I believe, I would assume that the child diversion team is using it, but it is very important that we focus on that element because the trauma is real. When you talk to our children, there's a lot of trauma that they're going through that they have experienced, and it is affecting their behavior. It doesn't just affect behavior too. We say we want to get better CSEC and PEP passes. The trauma is affecting their brain's development and their ability to learn. And so it's very important. I'm glad that you've raised it. The family interventions piece too, I am very glad that you have raised that because the family structure is behind a lot of the problems that we have seen, and the community structure too. And so the interventions can't just focus on the children, and I know your team, Minister Chuck, do family interventions, but I think having it defined in the legislation a bit more deeply is important, and just for us to understand how critical the family element is, because you can do all this fantastic work with the child and then they're back in a home that is dysfunctional and we undo all of what we have done. There was another point, and this is the more important point for me, is in terms of assessments of the children and where they are. What I have found and what I have seen is that a lot of our children that are acting out and doing other things, many of them do have special needs. And they may be on the spectrum, they may have ADHD. There are other elements that are there that need professional treatment. And we often don't spend the time to recognize some of these additional needs of our children. And so their ability to get through the program is compromised if we do not understand those elements also. So I just want to thank you again for the presentation, Chair, and I endorse a lot of what was in here.
Wonderful. Thank you, Minister Dana Dixon. Mr. Buchanan.
Thank you, Chairman. Now, Ms. Mackenzie, I just want to address two things. I'm 100% adopting what you said about the data protection. I have some issues which you probably can give me clarity on, or we can come to some solution. The proviso that you spoke of in relation to children under 12. The law as it is in Jamaica is 12 is the age of criminal responsibility. That being said, a child who is 11 has no criminal responsibility, and the law has no jurisdiction to interfere with that child, no matter how delinquent the child is. In fact, the Minister of Education, it's really her remit on the CPFSA, and that legislation controls that. So I saw you said something about proviso, and I just really wanted to wonder if it was a rethinking. Because when I hear India and when I hear UK, I can tell you Antigua is 14 and everybody sets their age according to society, culture.
The common law was about 16.
16, right, and the common law had it a different age. And we've had conversations about age, but the fact that you said something about the proviso and the assessment. Now, in family court, there is something that is called Gillick competence. And the senator, Gillick competence is the assessment of the child to see if the child can understand and appreciate. I assume that is where you are going, and that is a costly thing. The senator did raise whether we were going to do it generally or it was on a case-by-case basis. The functionality of the legislation also is what we need to focus on as we're trying to divert children. It's a very expensive undertaking for Jamaica. I'm not going to say government, but Jamaica. If we're going to protect our children, we have to make sure that we don't pass legislation that is theory. And then there's no functionality. Because the point man or point woman in all of this is the mentor. Currently, the Ministry of Justice has a robust justice of peace persons who are the mentors. One wonders where we go with that. Now, in relation to functionality, I love your contribution about including the family, because it takes a village. But in our current dispensation, if the wrong village take up your child, we have problems. My question to you is, if there is a broken home, if we are to adopt your recommendation, then there is going to be an incomplete diversion. If we put this into section 16.1 and it becomes a requirement, and the uncontrollable mother, father, some cases, they are grandparents, they are brothers, they are sisters, the realities of our society, it would mean that a child would be left out of the diversion because we have made a requirement and not put a case-by-case assessment, which I think the diversion persons are best suited to decide what it is. But I'm praying for your response. I know I said a lot, but your presentation was very engaging. And I had to just throw some hot water on it. Thank you. Thank you.
Before you respond, remember that.
Thank you very much. I think all the presentations have been excellent. Everything, the contributions have been fantastic. But I go back to my friend here has said it exactly. Functionality and theory. Now, I go back to saying that what the ministry has with diversion, we've heard from members of the team, real cases that they have been dealing with and results that they have gotten. I think the whole thing of looking at this act and seeing what we're going to revise has to be done with whether or not we are going to improve what we have that's here now, or create, and how to do it, or create laws and papers that will never come into reality in our lifetime. We always have to remember that we have to start and grow. It can't be big all at once. And if we bite off too much and we increase too much, then even what we have in child diversion now is going to get watered down and not things. So I would like to think that we have a good system here now, and if we are looking at this act or recommendations in relation to this, should strengthen what we have so that we get the maximum out of what is here rather than set our goals high and then we water down, we do achieve and improve on what we have, because what the ministry has with these agencies are excellent and we need to enforce them, build them, because all the contributions and the suggestions are excellent, but we don't have the capacity right now. The reality is to grasp and do all of them.
Well, you know, that has always been my concern. How far should we stretch the child diversion act? Indeed, I must tell you the truth. From this matter has been in operation for the last few years. I monitor it, and we know we have an excellent success rate. When I say really excellent. But you're right, Minister Dalrymple. You go stretch it, and then instead of a 70, 80% success, it dropped to 40 or 50%, and then everything comes. But at the end of the day, you know, we have to find ways and means to work with CCP and CFSAP, because unless we work closely together, we're not going to achieve the best interests of the children. So that is why I'm very keen to see how the legislation that Minister Dixon will bring up in a joint select committee, how best we can tie in everything together. So, you know, to be frank with you, I would like if CCP and CFSA were working well, get rid of child diversion. We wouldn't need it. We wouldn't need it, in other words. So what we really want is for child diversion to work with those other agencies to avoid cases coming to child diversion. So that is why I'm saying that interaction and engagement are really very necessary. Sorry, I still won't allow you to respond, but go ahead.
Child diversion, to continue working with them. You have to consider if they are going to, you're stretching them, so you're going to employ more, you have to pay more, you have to do more.
No, you see, no, we have doubled up.
Yes, and you have, but what I'm saying, so what you have is good, you know, and to stretch it where you can't reach.
Well, no, what I'm really hoping, and this is where we need to say how we engage the interaction with the other agencies to avoid more cases coming to child diversion. So you see, you want child diversion to be working with the Ministry of Education, with the Ministry of National Security agencies, so that we can identify and avoid cases coming to child diversion. I'm not denying that many will come, but you don't want to take on the work of CCP, the Ministry of Education, and the Ministry of National Security agencies. You just want to ensure that, and that's the point I keep repeating, how do we work closer together in the best interest of the children who, for one reason or another, are sort of misbehaving, getting delinquent, and then all of a sudden child diversion come because they're in conflict with the law. Sorry about this. Go ahead, Senator.
Minister, you have really summarized what needs to be done. And this committee, the discussion has been extremely interesting. What it has pointed out to me is how much people care about these issues and how much they want it resolved. But we have to refocus on the Child Diversion Act.
Exactly.
And the Child Diversion Act is relevant to children who are in conflict with the law. We cannot embark on solving and resolving all the matters that hurt us and that we are so concerned about. We have a focus. And that is why I agree with the last statement you have, Minister. What I think we need is perhaps to meet with those, they understand fully how those entities function and what are some of the problems which they are experiencing, because we have to have joined up government or it can't work.
Absolutely.
So I thank you for allowing me to say that, but just reminding us of the scope of the legislation which we are
Absolutely. Reviewing. Minister Cuthbert.
I just want to add on to what you said, Chair, and also what you said, Senator Motley Scott. Just agreeing with everything. I think we are not doing well at joint up government. I think there are so many agencies already doing something, and we do not want to take that on. Again, I mentioned what MNSP is doing with the case managers. No, what we need to do with justice is to work together to see how well we can work together to make sure that this joint up government is working, that you're doing what you're supposed to do with child diversion, we're doing what we're supposed to do. I believe the agencies, CPFSA has to do more. We need to see more work done with the CPFSA and to do what they're supposed to do.
Wonderful.
We need the agencies to work and to work for the best interests
Absolutely.
of our children.
Thank you, Minister Cuthbert. You wanted to come in, Minister Dalrymple? Okay. Could you go ahead and make the final comments, because we need to close off this.
Okay. Thank you very much. Thanks for the support of the presentation. Julian. And I will be brief. Yes, and I have heard, let me start with Chair and Minister Chuck. Sir, you've asked a question, how far do you stretch the Child Diversion Act? When we speak about the formal, Mr. Buchanan, when we speak about formalizing a trauma-informed approach, currently what obtains is that the officers and this is already incorporated in the training of the officers and the Child Diversion Committee. And what we are really asking is that it be formalized in the Act. So if you think that it should not be formalized in the Act, then because it is already being done. So we're just asking for it to be mentioned in the Act. But it's already being done with the Child Diversion Committee, and the officers are being exposed to that training. Right. So it's just to ask that it be stated in the Act. And Chair, you also ask about how do we work together. And I hear it coming out, and I hear Senator Scott Motley continue to say the gap. We're suggesting that sit together with all of the different agencies in a room, and then we can identify the gap and work with the gap. So we all know about resources, Mr. Buchanan, we do know about resources, and fine, I take your point in consideration, though, yes, we have to look at the resources, and we have to say balance, what is good for the child, and what is good for, and the resources that we have. So a balance will have to be struck there. I'm going to leave it to the legislators, so I won't get into that part of it. But yes, I think that is what I do have to say. And thank you for listening, and thank you for taking it.
May I just say, Ms. McKenzie, I want to thank you for coming here. As you can see, we appreciate the input. All of us appreciate some of the comments you have made. And from the comments that we have made, you know that we take into consideration a lot of the points that were raised by you. So we want to thank you and do express thanks to your members. Obviously, colleagues, we have a lot to look at. I mean, and what we're going to do, let me just tell you what is going through my mind now. We can't, a number of members want to go to some other meetings at once. So we're going to split this next presentation into 45 minutes more today. We stop at 12:45 so that members can get to their appointment at 1 o'clock. And then we are planning to come back in about 2 weeks' time to complete the assessment. And if anyone else has any more presentation, at the moment we have none, but one or two institutions have been in touch with Mr. Nash. We give them until next week. If it doesn't come in next week, we are not going to see them again. Okay, Mr. Nash? Right. No, in fact, we will see what is the presentation. If they submit something and it has been dealt with already, we'll just indicate we will take it, your submission, and look at it fully. Because what we want to do, colleagues, is to complete the overview of the Act, to identify some of the areas now that will need our debate or discussion, okay? And so we're looking, after today, somewhere around the 6th or 7th of May, for what could be our penultimate meeting. And then the ultimate meeting is when we make some decisions, to go forward, and hopefully a report will be prepared. Go ahead, Mr. Ahmed.
Thank you, Mr. Chairman. I didn't want us to leave here today without letting Mr. Barnes know that his contribution is so important and valuable. At his age and just his youthful exuberance and his participation, he is to be recognized for his contributions. I just wanted to put that on record.
And we would like your presentation, Mr. Barnes, should give some impetus to young people like at your age group to really participate in the governance of our various institutions. And I want to congratulate you for being a member of the disciplinary committee. Indeed, even JPs, we have reduced the age to 22 so that more young people can start to participate and give service to the country. So I hope when you're so minded, you might want to become a JP, okay? Very well, Mr. Barnes. All right. Okay. So we are going to, please, colleagues, we are going to let Ms. Wigan, give Ms. Wigan and her team 45 minutes. So just give us 45 minutes and we continue after that, okay? So go ahead, Julia.
So good afternoon again, members of the Joint Select Committee.
As you can see, she has prepared a huge document, an overview. I have told her, please do not read everything, just identify the main issues.
Yes.
Yeah, good.
Okay, so as indicated, I'm Julia Moncrief Wigan, Director of Public Law, Restorative and Preventative Justice. And with me, I have Mrs. Sandy Lou Cole-Jarrett, our Senior Policy Analyst and the lead on this Child Diversion Review submission. Next to her is Ms. Renee McIndoe, Assistant Crown Counsel. I'll just be making the introduction between Mrs. Sandy Lou Cole-Jarrett and Ms. Renee McIndoe. They will commence the initial discussion on the overview documentation for this afternoon and into the following dates to be identified. And as always, we are going to be supported by the Director of Child Diversion, Ms. Vanessa Clark, and her able parish child diversion officers, Ms. Stephanie Case and Mr. Levi Rodney. And so let me get into it. I had a lot to say at the introduction, and then when I heard the members speak, especially when you mentioned functionality as against the law, and that is why we gave you a very fulsome overview documentation. I will simply just say to you that the Child Diversion Act, when it was promulgated, it bared two major situations in relation to the child under consideration. And I'm going to read the memorandum of objects and reason because that gave the foundation as to why we have this 2018 Act before us. It contemplated in conflict with the law, and they're going to the courts, sentencing, and then after sentencing when they're incarcerated. And interestingly, over the weeks, we would have heard about the in-conflict being before the court and so forth, and the experiences from the different stakeholders and our ministry. But I'm certain you have not heard anything as it relates to the incarceration side of it. We have no evidence or information as it relates to an inmate who is a child and is incarcerated in the adult correctional facility. The Child Diversion Act provides for that. As it relates to a parolee who is a child, the parole board. And so I was happy when I heard you mention the functionality. We have this legislation, but there's just a focused area that we have been implementing, and we have not even touched on this aspect of it. And so just want to remind you about the object and intent behind the Child Diversion Act. And it is also going to be cited when we look at the overview for Section 3 of the Act, the object of the Act, yes? So we will start by simply, I'm not assuming anything, I'll give you the long title. We have all been saying Child Diversion Act 2018, but the long title is an act to facilitate the implementation of child diversion in the criminal justice system and for connected matters. Now, this act has 45 sections, 3 schedules, 5 forms, which are critical because also yesterday you would have heard about the forms not being prescribed and so forth, and the effect of what we already have. So just to say to you, now, because we're constrained by time today and over the coming days, just to remind you that in our initial submission, we would have identified the substantive areas. And so that submission document for the section by section overview, if you look to page 46 or 71, you will see even more details, notwithstanding this 109-page document that you have before you. And so let me speak to the memorandum of objects and reason. At the time, the bill then sought to implement child diversion in the criminal justice system. Child diversion involves the implementation of measures that more appropriately address the needs of children suspected or accused of committing criminal offenses. Child diversion, regarded as highly beneficial in the public interest, which we have been speaking about, and in the best interest of the child, providing, interestingly, 2 points: an alternate child-appropriate means of addressing the underlying causative issues of a child in conflict with the law. And the second important point, the opportunity to avoid the deleterious and stigmatizing effect on a child of a criminal conviction and detention in a correctional facility. Again, I say to you that there are 2 components, strong components, trying to prevent and then the rehabilitation when it has happened. So the issues as we speak to the correctional facility, or if you're a parolee, that has not manifested itself. When we go to the sections further down in the Act, we will be speaking about it. I'm hoping that we will have that opportunity too. So what are the other acts that facilitates this? It contemplated, as you know, the Child Care and Protection Act, the Constabulary Force Act, the Corrections Act, the Correctional Institution Adult Correctional Center Rules of 1991, the Gun Court Act, the Parole Act, and the Parole Rules. And so it is not a piece of legislation that only speaks to the, I like to use the word, pre-charged and charged stage. It also goes to once sentenced and convicted, what happens. But again, I'm emphasizing that we do not have the empirical data as to what happens when they're now in the correctional centers, and what takes place, or what happens if they are a parolee and what takes place. Nothing. We were hoping that we would have heard from the Department of Correctional Services yesterday on that matter. But Again, I'm emphasizing this part because we want to be reminded, are we establishing legislation that is primarily theoretical and settled and it is here and has no functionality, or we'd like to implement a legislation that we implement all aspects of what we carefully deemed required to treat a child in the best interest of that child and society. So that being said, I am going to hand over to Ms. Sandy Lou Cole-Jarrett, who is going to take us through the sections. I know we're of limited time, so she's going to particularly look at the first 3 sections of the Act. We'll be spending some time on the Section 2 because that section speaks to the interpretation, and so it defines the different aspects of what empowers this legislation and how we can apply it. So, for example, what does conflict, a child in conflict with the law, child diver, all the hot topics. This is a precursor to it. And so I hand over to Mrs. Jarrett.
Good afternoon, members of the Joint Select Committee. As Mrs. Spigon said, I will be going through the Child Diversion Act. This is meant to be a sectional analysis of what is actually in the Act. So this voluminous document that you have before you would actually have the specific sections. What we sought to do was to indicate specific sections that the ministry would have had issues with, to say that these go to the heart of the administration of the Child Diversion Program, and so we would want to have these discussed specifically by the Joint Select Committee. So part 1, the preliminary section, speaks to the establishment of the Act. So the Act may be cited as the Child Diversion Act 2018 and shall come into operation on the day appointed by the Minister, published in the Gazette. Of course, we take no issue with that. The definitions begin here, and in the Act, unless the context otherwise requires, appointed day means the day appointed by notice under Section 1 for the coming into operation of this Act. We take no issue. Approved counselor means a counselor approved by the minister under Section 20, subsection 2, and as we would have heard from Ms. Mackenzie prior, a suggestion was offered as to how we could possibly revise this definition based on how it is determined from the psychological point of view and what an approved counselor might mean. Approved psychologist means a psychologist approved by the minister under Section 20, subsection 2 as well. Best interest of the child shall be construed in accordance with subsection 20, subsections 2 and 3, and we would have spoken a lot about that in these deliberations. A child means a person under the age of 18 years. Child diversion means a child-appropriate process of determining responsibility and treatment of a child in conflict with the law without resorting to formal adjudication by a court. So I'm counting my words here because this is very important. So formal adjudication is not currently defined in the Act. And why this is important? Because it says child diversion is a process of determining the child's responsibility and treatment of child with conflict in the law without resorting to formal adjudication by the court. But what we have found is that by virtue of the processes of the Act, especially when we take into consideration the child being charged by the police officer on information to go before a court, that would essentially commence formal adjudication proceedings. And so we want to determine, for the purposes of the Act, when does child diversion end? And when does formal adjudication proceedings begin? Because as it is now, the two are mixed in the process of what child diversion is. So essentially, the definition does not align with other diversion provisions in the Act that contain elements of formal adjudication. For instance, when we look under Section 33. with the powers of the court. So the suggestion was to consider defining the term formal adjudication for the purposes of child diversion in the Act to enhance clarity in the application of diversion proceedings. And I believe the Jamaicans for Justice in their presentation would have also offered a similar suggestion to possibly define what formal adjudication is. The Child Diversion Committee means a committee established under Section 6. We take no issue. The Child Diversion Office means the Department of Government established by Section 4.1 of the Act. No issue there. The Child Diversion Program means a program developed under the Act in which a child in conflict with the law is required to participate. So again, we see a theme here. Child diversion meaning child diversion program, they both speak to children or a child in conflict with the law. We have identified a possible issue here in that the reference to the child diversion program as it is in the Act seemingly speaks to the individual programs created for a child pursuant to the Act. However, in the administration of the program, the overall program is called the Child Diversion Program. So it begs the question as to whether we want to consider keeping the overall program as the Child Diversion Program, but possibly finding another reference, maybe a child diversion plan for children in conflict with the law, instead of saying it's the Child Diversion Program, just so not to conflate the terminologies when it is being used. Very importantly here again, Child Diversion Program means a program developed under this Act in which a child in conflict with the law is required to participate. Emphasis on required to participate. In the context of the Act, there are several provisions that would have spoken to or speak to the child having to consent to participate. But the definition actually here says the child is required to participate, but it's not in all instances. If the child is being offered or referred to child diversion, the child has to consent. So are they really required or mandated to participate? So we have to look back at this definition as to whether it is in the context of the child from the standpoint of the diversion being offered through the police versus the diversion being mandated by the court. So is it that when it's at the police stage, the child has to consent, but if the child ends up before the court, can the court mandate that the child participate in the child diversion program, or is it that at that point the child still has to consent? So was it the intention of the Act in the use of the word required to participate? Did it mean to capture the court process and not so much the pre-diversion stage where the child is at the police referral stage? So that is a matter to be considered. The child diversion referral order, so it's an order of the court referring a child to a child diversion program for participation in a child diversion program under Section 37. And just for consistency, the schedule actually has order of referral to child diversion program as the title. So we'd want to change that in the language of the provisions in the Act, just so it aligns with the reference in the schedule. To borrow from Mrs. Wigan, I'm about to approach a hot topic definition. So, child offender means, as applicable, a child who is suspected of, accused of, charged or convicted of a diversion offense and accepts responsibility for a diversion offense as set out in subsection 4. B, an inmate who is a child serving a sentence in an adult correctional center or a juvenile correctional center, or C, a parolee under the Parole Act who is or was a child at the time of the grant of parole. So as Mrs. Wigan would have said in her elaboration on the mention of the objects and reasons of the Act, as you can see here, the Act meant to consider children in conflict with the law from two standpoints: those who would have been accused, not yet charged, those who would have been convicted and sentenced, and those who are inmates, hence why we have the definition of child offender. So the issues that have been identified here by the ministry: one, reference to a child in an adult correctional facility. Do we really want to have in this legislation any reference to a child being in an adult correctional facility? So we may want to consider removing that reference, and that would be under subsection B. So it currently reads an inmate who is a child serving a sentence in an adult correctional facility. So that is point one. Point two, whether child diversion under this Act is actually applicable to children convicted, sentenced, the child offender, in the context of the other legislative definitions. So who is a child in conflict with the law, the child diversion program? Because if you look back at those definitions, it's meant to address specifically children who have been charged, not yet sentenced. If you look under Section 9 as well, I'm just trying to do the connecting clauses at the same time. When you look at the requirements for the child to be referred to the child diversion program, the child has to consent, the child has to accept responsibility. Now, if you're already an inmate, if you're already sentenced and convicted, how are you now going to accept responsibility, consent? What are you going to accept responsibility for? Because it would already be assumed that having gone through the entire court process, you have been convicted, whether you pled guilty or not. You would have gone through that process already. So how do you then, as a child offender, come back or be presented before the court again for a diversion program? Yes.
I don't want this part to pass, but a person who is convicted has appeals, and then the DCS legislation, the DCS aspect of it, treats the person as an appellant. That person, it may very well be that to benefit from child diversion, you would abandon the appeal, which is unappropriate. And there are persons who, notwithstanding the conviction, up unto the Privy Council, they maintain their innocence. And acceptance of responsibility may give them a door or a window.
Mr. Buchanan, we have to get over this thing. If child diversion is to work, there can't be any guilty verdict.
The reality is, I'm
saying at the moment
where exists. It is. What I'm seeing though is a second bite at the apple, Chairman. It may very well be that. No, what I'm saying is, it may very well be that the spirit of the legislation is saying the child isn't lost even after going through.
Well, that's a different matter. That's a different matter. What we're really saying is, and this is where we need to get the legislation straightened out so it is unambiguous. For child diversion to work, it is diverting the child away from the formal justice system. If the child doesn't agree and they go through the formal justice system, they're going to get a conviction. And I'm not even too sure that at that point it's child diversion. Because
Commissioner, if you would permit me, as the legislation is currently drafted, it shows that the child convicted still have the option for child diversion. It may remove the conviction, the adjudication.
But this is the problem, you see, Mr. Buchanan.
No, I have that, but I'm speaking currently. We're amending now, but as it is right now, there was a retroactive component because there are children now who have been convicted, and
but you see that's what I'm saying, Member Buchanan. That has been the conundrum. It is just unfair to the child that you pleaded guilty. you go through the program of child diversion successfully, and you still have the conviction? Because you can't remove it.
It is actually suggesting that it can be removed.
How? By how?
By final adjudication. When I read the sections, it does say that the judge has the ability at the completion of a child diversion.
I don't know how that's possible.
It's the legislation.
Samantha, just a second. Let me just ask it, Joel. Ms. Eden, what are you saying?
Good morning, Chair, members of the committee, colleagues. So, in support of the observation that has been raised by the ministry, the scope of the definition, at the time when the Act was originally passed, there was a raft of consequential amendments that were also done. And so I would bring to the committee's attention, although we're sort of jumping ahead here, I'm trying to find it. I believe this is the...
Were you originally responsible for the Act, Ms. Eaton?
Yes, Minister.
I know I was too, but
yeah.
so any weaknesses, you and I should be blamed, right?
So you'll observe that in the fourth schedule, there was a raft of consequential amendments that were done in support of the policy. So I'm on page, I'm looking at the actual bill.
Yes.
So the fourth schedule, amendments were made at the time to the Child Care and Protection Act, as was mentioned earlier by Mrs. Moncrief-Wiggin, and also the Corrections Act. So you'll observe, I'm trying to find the page, the Corrections Act, I believe this is page 60 of the bill that I'm on, amendments were introduced in the Corrections Act to treat with the child who is incarcerated, yes. And so I think that definition was an omnibus definition which was taking into account not just the provisions of the Child Diversion Act, but also the scope of the policy that was implemented in respect of the consequential amendments which are specific to those enactments. So there is an issue with the definition.
Right. All right. Ms. Cole-Jarrett, go ahead.
Right. And so just to wrap up on this point, this suggestion or how it is actually placed in the Act would have been based on the policy, because if you look at the child diversion policy, it would have had 4 tiers of child diversion. The latter one, or the last one, the fourth one, being to address children who have already... So it is clear that that was the intention, but when you look at the provisions that speak to that, in the context of the general framing of the Act, it is not supportive. Again, I reference Section 9, which says that child has to accept responsibility, child has to act, which wouldn't apply to a person who has already been convicted and is sentenced. So if it is that the committee decides that we still want to keep the child offender and the possibility, as Mr. Buchanan is advocating for, it seems, for them still to be given an opportunity, then we would have to look back at all the definitions in the Act to be able to support a child offender.
Go ahead.
So I just wanted to make this point here that what we're identifying is just to try and bring everything to be, not to be incongruent with the provision, but neither are we promoting, because the intent of the policy and the Act, and that is why I touched on the correctional acts, the parolee, is the component where we want to rehabilitate, reintegrate, integrate the children, right, and to reach them, notwithstanding that they have been sentenced, but to touch on that part of it, to think.
If I may jump in here, the Correctional Act, we already have robust rehabilitation for reintegration in the correctional facilities now, in our juvenile centers and also in the adult correctional facilities. And so I don't think we need to do much more. And when you come to child diversion, it is somewhat child diversion, diverting them, making sure that the recidivism rate is not here. We've seen it where it's dropped from 41% to now 20-something%. So there is good rehabilitative programs in the correctional facility, which is which is child diversion, to show them another pathway to make sure that they don't reoffend.
Quite.
So I'm,
Quiet. No, I agree. Continue.
So there are connecting clauses to that would speak to the child offender. So the committee would want to look at Section 9, Section 11, Section 34, and Section 44, which specifically makes reference to the child offender in the context of what it was proposing there. Next definition, Commission of Corrections means the office established under Section 3 of the Corrections Act. We take no issue with the definition there. But just to note that the Commission of Corrections is referenced in Section 7 of the Act, specifically in relation to the functions of the Child Diversion Committee from a consultative standpoint. Conflict with the law in relation to a child means taken into custody of a constable on suspicion of having committed a diversion offense or detained or charged with a diversion offense. Again, it takes into before the child was convicted, sentenced, and conflict with the law is at the heart of what we're discussing here. So you see the contention. So the definition would not fully capture the gamut of the act in particular in relation to the child offender. Correctional institution has the meaning assigned to it by Section 2 of the Corrections Act. We take no issue. Correctional officer has the meaning assigned to it under Section 2 of the Corrections Act. No issue. Diversion offense means an option specified in the first schedule. That's the first schedule to the Act that outlines the offenses for which child diversion may be applicable. B, any other offense for which the court may make an order referring a child to participate in a child diversion program. So we see here, this is very important. It would have been discussed before the committee on prior occasions where issues would have been raised as to whether or not child diversion is only applicable to the schedule of diversion offenses as is. But as you can see here, under B, any other offense for which a court may make an order referring a child to participate. So the court does have the remit to go beyond the schedule of offenses that are listed in the Act currently as diversion offenses. We take no issue with this definition. Diversion option means one or more of the options available for inclusion in a child diversion program specified under Section 16. No issue here. Guardian in relation to a child includes any person who has for the time being the charge of or control over the child and any other person who is legally liable to maintain the child. No issue here. Lockup has the meaning assigned to it by Section 2 of the Corrections Act, and we don't take issue with it in the context in which it is used here, because if you look under Section 11, it is pretty much saying that we're not to lock up a child if that child is a part of a diversion program. And so while the child is a part of the diversion program, that is not an option available to the police, locking up the child. National Child Diversion Oversight Committee means the committee established under Section 8, no issue. Order to make amends means an order made under by court under Section 36, no issue. The Parole Board means the board established by Section 3, no issue. A police caution means a caution by a constable under Section 25 of the Act, no issue. Police warning means an informal warning by a constable under Section 22, or B, a formal warning by a constable under Section 33. We take no issue. Remand center has the meaning assigned to it by Section 2 of the Corrections Act. We take no issue there. Reparation order means an order made by a court under Section 35, no issue. Restorative justice program has the meaning assigned to it by Section 5A of the Criminal Justice Reform Act. What the ministry is proposing here is that we may want to define restorative justice from the perspective of the restorative justice program executed by the ministry as opposed to the reference to a restorative justice program as defined by the Criminal Justice Reform Act. No, not name the ministry, just redefine what restorative justice is from our standpoint, since as it's a separate program, but it also forms a part of the child diversion options when the program is being designed. Suspended sentence order means an order made by the court under Section 34E and 38. Now, this is an issue for the ministry, though we don't take issue with the definition itself. It's what the definition means in the context of child diversion. So, outside of issuing an order pending a child's completion of a child diversion program, if issued for any other purpose, may run counter to the intent and purpose of child diversion. So why would you want to issue a child with a suspended sentence order, a child in a child diversion program? So if the child goes before the court and the court recommends that the child be referred to diversion, an option as well is for the court to give a suspended sentence order. But what does that mean for the child? Those things are being recorded. The child is left pending the completion of the program, not knowing what will happen to the child when the child comes back before the court. And so we may want to look at whether or not we want the act to address, in the context of a child, having a suspended sentence order as an option. And it is in several sections of the Act. So 11.2D, 34.2E, and 38. Victim means a person who suffers physical harm, psychological harm, injury, loss, or damage to property or financial loss as a direct result of an act committed or suspected to have been committed by a child in the course of a diversion offense. So while the definition of a victim covers several important components of victimization, a victim can experience harm, damage, or loss beyond what is explicitly listed here. So we're just suggesting that the definition have a catch-all to be more all-encompassing, so any other consequential harm or loss, whether tangible or intangible, suffered as a direct result of an act committed or suspected to have been committed by a child in the course of a diversion offense. We have some proposals here for consideration in terms of inclusion in the Act as possible definitions. I would have indicated formal adjudication before, defining that so that we are certain when the child diversion process ends and when formal adjudication commences. Acceptance of responsibility is currently not defined in the Act, and it is a large component of the diversion process. So the committee may want to consider indicating in the Act or offering a suggestion that the Act explicitly indicates what acceptance of responsibility means, and more so saying that it does not require the child to enter a guilty plea. So moving on to crave your indulgence. Where is it? Yes. Okay.
Yes, I have a few comments to just make. We are coming towards the end, as I say, and we need at least another 2 more sessions, not only to complete the overview, but I think in the light of the fact that we really didn't finish the overview today, we may well have to look at the possibility and put it in no higher than that. As we go through, we start to look at the sections that needs, some further considerations, which is what is happening. And it may well be that I'm going to ask the team, you see the team here on the left, they will have to pull together over the next few weeks to, should I say, digest all the presentations, highlight some of the recommendations, which is the matrix. But in a sense, we don't necessarily want an elaborate matrix of everything. We just want to identify the relevant recommendations that came from the presenters and where from the history of the child diversion, and also from the recommendations, identify the sections where they had some recommendation, and probably put some options available to the committee for the committee to deliberate and make a decision. So that over the next couple of weeks, I'm going to ask the team, you know, Ms. Wigan and Ms. Jarrett and Ms. Renee, and the members of the team, including the drafter, they have been working closely to weekly meet to find out where we're going. And in a sense, we really want to send in a report by the end of May. This is why I asked Mr. Nash if he has started to draft the report already. So he better start this weekend. Because at the end of May, or, you know, I'm using that as a target. We want to present the report with all of the various all of the presentation from members. And hopefully in June, sometime in June, we debate, and that will be the end. Because we have had an excellent set of deliberations. So we want to be able to present to Parliament that we have gone through. These are the recommendations. Ask for Parliament to adopt it. And then those amendments we can put to the drafter who is with us. They're not a lot, but we need to just straighten out so that some of the anomalies and conundrum that we have encountered, that they're cleared up. Yes, Member Buchanan.
Chairman, if we're going to meet that deadline, what is significant is Section 44, and I think that's something that we need to grapple with, all of us outside of this setting. I'm raising it because a lot of the gaps or the confusion is the transitional element when the act was. So a decision may very well need to be taken if that transitional period has passed and these things are removed entirely, as in struck out. And the drafters are the best person to give guidance on that. But given our previous conversation, I'm seeing a lot of the definitions kind of become inadequate because there's a transitional period which has pretty much has passed.
And to be frank with you, my hope is that when we complete the amendments, we make it very clear that child diversion stops with the charge, the recommendation, so we don't need, to talk about suspended sentence, because those are when the child has not completed the diversion program properly, and then they're convicted because they have not complied, so they're charged. So at the end of the day, my hope is that when we have straightened out the act, we make it very clear that we're moved away from the courts system. You give the child the opportunity to go straight. Once they go straight, that's the end of the matter, as far as I'm concerned. No, right, you have to. Right. So at the end of the day, including colleagues and members of the team, we're going to add who can recommend to the child diversion, the DPP or the prosecutors. And if that happens, it may well not even go to court. Okay? And only when a child fails to complete a proper child diversion that it might end up in court. So we are looking towards that. So if we look towards that, a lot of the definitions can be excluded. Because as Mr. Buchanan say, in the transition program, a lot of the definition, a lot of the sections can be taken out because child diversion should look at children who don't have to go to court. You see. All right? And once they have to go to court, then it really is a matter for the correctional services or for the judge or for the probation officer and so on. Because that the point about child diversion, we're going to try as best as possible to work with the children, and once they can go through the child diversion program properly, that's the end of the matter. Where they can't, they're back into the formal system. So, colleagues, please, I thought we were going to go on much later, so I'd ask for some a little snacks downstairs, so please join us downstairs for snacks. But we're not going to go on too late. And Ms. Mackenzie and Mr. Barnes, you could join us downstairs, please, because we thought we were going to go to 2, 3 o'clock today, but we decided not to. Could we formally adjourn the meeting? And the likelihood is that the next meeting is about the 7th of May, but we'll confirm, okay? If we go to another 2-hour program, all right? Meeting adjourned.
When making short crust pastry. There, 1/2 to 1. 1/2 fat to 1 flour. This means if we're using 1 pound of flour, we would use 1/2 pound of fat. Okay, I'm going to give you one to work out for yourselves. If you're making short crust pastry,